Quorum, so we will call the Regulated Industries Committee meeting to order. Committee members, if you will look in your folders, everything is in the order that we intended to cover them here today, but they're stacked in the order that you have on your agenda, and you will find in any case where there's a substitute, the original bill first and then the committee sub underneath it. There are a couple of amendments that have been presented to me on two of the bills that will be received if they're appropriate, that committee members want to. Any of you who wanted to speak on bills, we had sign-up sheets outside, and we just collected them, so I hope we have you. If we skip over anybody, we will see if we can give you a chance. We obviously have a very packed schedule. I have put every bill on the agenda that a sponsor requested a hearing for. And with one exception, a governor's bill, they are in the order that they were filed with the Secretary of the Senate. And I feel like that probably gives a little indication how important they were to the authors, people that waited around till a week before crossover day must not have been too enthusiastic about their bills or busier on other things, and they may not get reached, but we'll hear as many as we can here today. This is our last meeting, and there's another meeting of ethics at 6 p.m., so we've got a fairly tight window. Because of that, I may be a little restrictive on testimony. A couple of these bills have already been heard earlier and just had some tweaks and changes made to them that shouldn't be as complicated or intimidating as this list looks like. Majority Leader, you are number one on my agenda, so I'm going to ask you to present Senate Bill 146 by committee substitute, and you can do that from your seat if you would like to.
Will do. To save time, we know how precious it is. I won't go back over the entire bill. This bill deals with the foundation and structure of establishing some guidelines and policies moving forward dealing with the EV industry. We know the EV industry is growing. Some think it's growing faster than others, but it's coming. We have to be prepared for it. The bill basically does three things. One, it allows for the sale of electricity not to jeopardize the Territorial Act that's so sacred over at the PSC and with utility companies. It allows for the sale of electricity at the charging stations by the kilowatt hour, not by time. That's one of the main focuses of the bill in Section 1. Section 2 deals with the inspections and the permitting and the regulations of how we set up the charging stations. It will be somewhat similar to what is done on gas pumps today, and that will be regulated and monitored by the Department of Agriculture. We had testimony by the attorney for Commissioner Harper at our last meeting. Commissioner Harper is in full support of this legislation, and he stands ready to implement the inspections and the permitting requirements in the bill, subject to funding, of course. And so that'll be something we'll talk about in our budget process this year. And then the last part of the bill that we are talking about deals with the taxation portion of that, because of the fact that we will be losing motor fuel tax as these electric cars begin to roll out and be using our public roads. We feel strongly that they should pay their fair share of the motor fuel tax that the DOT depends on solely to maintain roads and bridges. Now, at our hearing we had a couple of weeks ago, we had a lot of testimony from everyone that seemed to be supportive. There were some recommended changes by some people in the industry dealing with Teslas and specifically, and also with some of the utility companies and the charging companies. And so all of those recommendations went through my office, and my chief of staff, Ben Gerard, worked with them over the last week to 10 days, and we've come up with this sub that we believe satisfies everyone in the room. We have not heard from anyone that's in opposition to the bill. There are two amendments today that basically is just cleanup language and further clarifies what the intent was for the bill when it was originally written and then later subbed. And so if you need me to, I can go through the full details of the bill, or we can just move on to the amendments and then see if there's any other discussion.
We have had a pretty thorough presentation on the bill earlier, back in middle of February. Before that, you gave an update on the study committee we had this summer to educate the committee members of the issues.
Correct.
So I think what we'll do, members, if you'll look, the very first document is this Senate Bill 146 as introduced with the summary. If you'll flip right behind that is the committee sub we're working off of, substitute to Senate Bill 146. It's LC 393817S. So it'll be your second bill in the pile. There's a separate summary sheet in front of it that'll address it. Y'all got it? Okay. The number's 3817S. You got it. Mr. Leader, if you would first, it's very few changes you made in the committee sub. It looks thick just because the original bill was. If you would highlight the changes and then discuss with us the proposed amendments. You'll also see, committee members, there's two proposed amendments behind the committee sub. They're on single sheets of paper. So let's talk about the changes in the committee sub
no problem.
first.
The main change is line 68 through 73. That deals with the term and the definition of a residence. We initially had it set up for a single-family home. We added multifamily homes as part of that definition, but we use the same language, Mr. Chairman, as we use in House Bill 170, and that is for a multifamily home with someone that is a tenant who lives there for 30 days or greater. That way you don't have Airbnbs and other type tenants moving in and out like a hotel arrangement. So this would be for people who are permanent residents of the apartment or the single-family home. And what this means is they do not pay any kind of tax on that charging station, because primarily we would never know who all has a charging station in their garage or in their basement. Right. So this basically gives them the exemption of the tax, the equivalence of the road tax, but I will remind you, they are currently paying the $200 fee per year for that tag. And so we believe that's a fair number at this time to use that $200 fee. If they're going to drive that electric car a long distance and they require to be recharged and they pull into a public charging station, that's when they would be charged the additional tax at that public charging station, not at their home or their residence.
You had a discussion last time about how we were going to calculate an appropriate tax based on kilowatts to equate to miles per gallon, et cetera.
Yes.
Is there a place that you changed in here?
We'll get to that in just a second. Right. So lines 90 through 96 was a recommendation that all the charging stations agreed to, and that is that we would adopt the National Institute for Standards and Technology of the United States Department of Commerce. Those are the regulations that we think are appropriate because they would be more consistent throughout the United States and they wouldn't change from state to state. So everyone agrees with that language as well. Lines 97 through 103 was a request by the Department of Revenue, which they asked us to put into this bill, and it deals with confidentiality of information pertaining to the information from these chargers and the riders who would be using those. Lines 104, which is code section 10-1-222, deals with basically the chargers that are owned by Tesla. This is the Tesla language. Does not require a digital meter or a measuring device on the charger itself, but an app can be utilized through the digital network app, which is also defined earlier in the bill. Let's see, go on.
Are those in cars now? When I was reading that, some of them equipped with that app?
I think the senator from the 27th has personal knowledge of the Teslas. I do not, but they do have the equipment that is already in place, and I think they pay a subscription fee per year, and that gives them free charging in any of their Tesla chargers. Is that the way it's done now, Senator?
Depends on when you bought your car. Some people got lifetime free supercharging. Some people have to pay for supercharging, but everything as it relates to charging at a Tesla supercharger location is managed through the app. There's no meter that you see in terms of energy output or anything.
It records that data for us that we could use. Got it. All right.
So that takes care of the Tesla language, and then you skip on back. Most of the rest of that is the same. Go to page 14. At the top is where we do amendment number 1, and this is the Frank Ginn amendment. On lines 319 and 320, we will change kilowatts from 9 kilowatts for gasoline to 9 kilowatt hours for gasoline. And then again on 320, it will read 14 kilowatt hours for diesel.
Frickin' genius.
So we thank Senator Ginn for his insight to that mess on the bill originally. The amendment number 2 is cleanup language and clarification of what's already been agreed to by the stakeholders in Georgia Power last year through the rate case study with the Public Service Commission, and it deals with the EV charging issues around the state. This amendment says that if Georgia Power decides to go into the competitive charging business outside of their PSC-approved community charging program, then they must do so through an unregulated subsidiary, sort of like the cross-subsidy language we had under the broadband provisions. The amendment preserves Georgia Power's Charger of Last Resort program for rural and low-income areas, which are basically Tier 1 and Tier 2 counties. The amendment also provides that Georgia Power will provide EV charging services under the same rates, terms, and conditions of service as private sector providers. The amendment was requested by Americans for Affordable Clean Energy, a coalition of national convenience stores, and is not opposed by Georgia Power or the EMCs.
I wouldn't expect them to oppose being unregulated. Is that what you're saying?
Georgia Power?
This subsidiary would not
They
be
are
subject
not.
to
They are
regulation?
not. They are not regulated. The subsidiary would not be regulated, but they would be set up as a separate entity, like another corporation.
Similar to their outdoor lighting program.
Any
And- that's right,
questions
and
from
National
committee
Gas.
members of Majority Leader? All right. Senator Summers, you're recognized.
Senator Gooch, there was a question somewhere, and I can't find it here, and I had it written down about the probate judge doing something about repossessing the meters. What was that about?
That was under the part in section 2-2.
Okay.
The Department of Agriculture. It's just the enforcement provision of how you would enforce the regulations that are set forth by this new code
The
and by the
agriculture department or the
regulations.
probate judge?
I think it's the probate court through the Commissioner of Agriculture, but I don't see that section on here.
I can't-
That did not change from our previous meeting, so.
Okay. I still just quite haven't figured it out. Thank you.
Any other members have questions? All right. Well, at this time, your bill is before us for consideration. Any motions by committee members concerning Senate Bill 146, the committee substitute, Senate Bill 146? And I'll-
Chairman?
Yes, sir.
we need to do
Senator
that
Albers.
with Amendment 1 and 2.
I would make a motion to pass LC 393817S.
All right, is there a second?
Second.
All right, and there's a second. All right, now, the appropriate time to offer any amendments that any member feels are necessary.
Sure. You want to do those?
Mr. Gooch, I'll recognize you or Senator Albers, either one.
Thank you, Mr. Chairman. I will continue here with amendment number 1, which is AM 390338, as described by the bill's author that's in everyone's folders.
That would be the little one-page bill that just deals with the kilowatt hours, right?
That's
Correct.
Again, amendment.
We'll call it the Ginn Amendment offered by Senator Albers. Is there a second?
Naturally, I'd second that.
That would be
should.
appropriate. All right. Any discussion on that? That's pretty clean, just going from kilowatts to kilowatt hours.
I'd like to call it freaking genius.
Objection.
All right. All in favor, let's raise
Just
your
gotta know what
hands.
you're dealing with.
And are there any opposed? All right, that's going to pass unanimously. Any other proposed amendments?
Yes,
There's
sir.
a
I'd like
two-page
to,
amendment there.
move we approve amendment number 2, which is AM 390339, which is in your folder and before you, that I did discuss, and it's basically dealing with the PSC agreement and further clarification.
Is there a second?
Second.
Second by the freaking genius again. We're ready to take action on this one. Any discussion? All right, all in favor, raise your hand. Any opposed? That also passes unanimous. If any of you in the crowd are wondering why I didn't allow any testimony, it's because the sheet's blank. Nobody had any further testimony, I think.
Good.
I think everybody had their say on this when it came before our committee earlier, And maybe it's right that everybody's in agreement there, Mr. Leader, with your change.
So far, so good.
All right, any further discussion on Senate Bill 146 by committee substitute? We're working off of LC 393817S. All right then, it's on the floor here. All in favor, raise your hand. It's as amended. Any opposed? All right, good work. One down, 8 to go.
Fast and furious. I have my amendment back there.
I'm gonna call a bill out of order
Trying to steal my stuff.
because I've got pressure
Autograph.
from Bo Hatchett, who's bigger than most of us here, and the governor's floor leader. If you'll look on your list, this is the 5th one down. It's Senate Bill 260. Senator Hatchett, if you would please present this to us. So now I've messed everybody's order up. You're gonna have to dig down in your pile of few to find it. Senate Bill 260.
Thank you, Mr. Chairman. And I've got Josh Stevens here from the Georgia Department of Economic Development who can answer any questions that I'm not able to, if that's permissible.
That is.
I'm bringing Senate Bill 260 on behalf of Governor Kemp. As many of you have heard, Governor Kemp has laid out a vision for Georgia to become the electric mobility capital of America, which we are well on our way to accomplishing thanks to the support and efforts of this body, as well as the partners across the state government and the private sector. In July of 2021, Governor Kemp announced the formation of the Georgia Electric Mobility and Innovation Alliance, which was a public-private partnership led by the Georgia Department of Economic Development, and constituted a statewide initiative between government and industries, electric utilities, nonprofits, and other relevant stakeholders. The partnership was focused on growing the electric mobility ecosystem in the state and strengthening Georgia's position in electrification-related manufacturing and innovation. The EMI's mission was to support the growth of the entire electric mobility industry and foster innovation in the state of Georgia by creating a business-friendly environment for the industry and promoting favorable public policy. This bill accomplishes the following. It allows the Georgia Department of Economic Development to create a statewide electric vehicle manufacturing program for the promotion of electric vehicles and components in Georgia, advance the electric vehicle industry in Georgia by marketing, recruiting, and promoting. And I want to state this specifically. This program may not address the sale, distribution, or servicing of electric vehicles. So this has nothing to do with the direct sales or anything like that. And the second thing this does is it creates a Georgia Electric Vehicle Manufacturing Commission. The commission will be comprised of a variety of stakeholders and will formulate recommendations to the governor and the General Assembly to support the program and to advise the department in meeting infrastructure needs for the EV industry. It will also help develop marketing materials and advertising to promote continued EV industry growth in Georgia, and it will continue work and progress made by the Electric Mobility Innovation Alliance.
All right. Any members have questions? Trying to, Senator Brash, you recognize.
Okay, so you had stated that it is, the intent is for them not to get into direct sales.
Yeah,
Can you say that again?
The program may not address the sale, distribution, or servicing of EVs.
Okay. But it says on line 31, the program shall advance the state's interest in developing, marketing, promoting, or recruiting the growth of the EV industry.
Yes.
Okay.
Yes.
All right, so they're not going to be making any recommendations on how to sell these things?
No.
Ever? Ever?
Not with this bill.
You're going on record and saying ever?
Not with this bill.
Okay.
Well, let's back up a little bit too. We've spent a lot of time in this committee about the powering these things up, charging them. Is this rulemaking or regulatory authority going to interfere with that, or is that going to be left to the legislative branch?
To my knowledge, it's going to be left to the legislative branch. Obviously, this is just a commission. Josh, do you have a comment on that? If he can, as chairman.
I'll be very brief, Chairman. It's related to marketing and promotion.
Introduce yourself for us, Josh.
Yes, sir. Joshua Stevens, Director of Policy and Government Affairs, Georgia Department of Economic Development.
Okay.
Super dad.
And me just reading through this, it was late, dropped bill. No big deal with the consultation with employers, et cetera, gathering information, making recommendations to the governor. The marketing is fine. We need to do that as a state. I don't think you get any pushback. I'm just curious about any rulemaking authority that the commission may be given.
Yes, sir. No, we'd be happy to address those if there's any suggested clarifying language that you'd like to see in there.
I'm gonna point you to line 95. I guess this is really directed at the Commissioner of Economic Development. Shall be authorized to promulgate any rules and regulations necessary to implement and administer the provisions and further promote that marketing. That sounded narrow enough to me that that's what we're doing, is marketing the industry and making sure we get folks trained up to work in it. Just want some assurance that that's it, because we spent a lot of time kind of laying the groundwork of how we're going to regulate this industry. Want to make sure that remains a legislative function.
Yes, sir. Understood.
Okay. Senator Dolezal, do you have a question?
I do, Mr. Chairman. Thank you, Senator Hatchett. Hello. Want to ask you about lines 39 through 42, which states that the department shall be authorized to contract with the Department of Transportation's CERTA, GTA, Georgia Environmental Finance Authority, and other instrumentalities of the state for the construction and maintenance of infrastructure which support the EV industry. Can you clarify what you all have in mind with that particular section of this bill?
Yes, sir. Tell me those lines you were saying.
39 through 43.
Okay. Yes. So we've got, to my knowledge, this was fairly straightforward in the way in which we've approached it in terms of forming the commission. I don't have any context to add as far as the contracting with these other agencies. What I will say is that this was based on the governor's previously announced Electric Mobility and Innovation Alliance, EMEA, that was mentioned, where we engaged a multiple or variety of stakeholders, including those entities mentioned there, mostly through the Department of Transportation, but also other partners in the transportation space as well.
All right. Well, we applaud that program. It's made Georgia a leader in the industry, and we appreciate your efforts in this regard. Any other committee members have questions of the author or Josh? All righty. Thank you very much. What is the will of the committee on Senate Bill 260? All right. Was it 260? There's a motion and a second. Any further discussion? All right. All in favor, raise your right hand. All opposed, like sign. All right. It's also unanimous.
Thank you, Mr. Chairman, members of the committee.
Thank you. Senator Gooch, how detailed is Senate Bill 193?
It's quick and
I have it.
fast and furious.
All right. You recognized on that if you can fastly and furiously move through. I'm going to defer to you.
Okay. All right, so not to go back to all the years of work we've done on broadband, but you recall all the different bills we passed dealing primarily with mapping and trying to get an idea of just where the served and unserved areas are in Georgia. We did that. That map has become basically a nationwide model for other states to adopt. However, with the federal funding that we have received in the last 2 years, there's two different funds that are coming down, maybe more, from Washington. There's some requirements that we have to adopt to clarify some of our language that we adopted previously. And so that's what this bill does. It attempts to provide clarification. It also allows for the Department of Community Affairs and the Georgia Technology Authority to share data, but it's to hire and utilize third-party consultants to help them with that data collection and that data sharing, not to allow any of this private data to be shared beyond the scope of the work that they're doing internally for us. And so that'll help us utilize that information to make better decisions when we authorize these grants to be given to these communities, which we've been very successful with doing for the last year and a half. And so that's basically all the bill does. It protects the private data by the providers, specifically to the served and unserved areas, which are defined by 23 megabits up, 3 down. 25 megabytes down and 3 up, but it also deals with the data sharing of areas of the state that are underserved, which is defined by the feds as areas with 100 megabytes down and 20 up. And so again, it's all clarification. It allows for the mapping and the data to be better utilized for these grant programs. I do have a small amendment. Again, it's just further clarification by one of the providers, and I believe everyone agrees with that provision as well, and I can offer that amendment at the appropriate time.
All right, so for committee members, you will have in your file Senate Bill 193 as introduced with the summary, and we never really had a chance to even look at that one before this substitute came in. We're working off of the substitute to Senate Bill 193, LC 365545S. Everybody got that? And this is the amendment that's a little one-liner that's AM 360913.
That's correct.
Am I right that your entire motivation here is just to get us in sync with federal requirements to qualify for their loans?
That is 100% accurate.
And
So we
this is
can-
the $1 billion, $1 billion plus that we've heard
That is correct.
talked about?
That is correct.
Anybody else want to be heard on this bill, on Senate Bill 193? I had somebody signed up and changed their mind and scratched their name out. I was happy to see.
This
All right.
may be the first time in our legislative history on broadband legislation that everybody is singing Kumbaya.
All right.
So we're happy.
So what's the pleasure of the committee?
Move to pass.
Move to pass by Chairman Ginn. Is there a second?
Second.
Second by Senator Albers. He beat you to it there, Mr. Pro Tem. All right, any further discussion? And you have your amendment you want to propose?
The amendment that you should have in your folder. Your amendment in your folder should be AM 360913. It basically replaces line 74 by inserting the following: requires these locations to be eligible for funding under each program, the Department of. And so it says applies only to federal programs, not state. So that is the
You're
underlying
offering
meaning
that.
of
Is
the-
there a second for that amendment? And a second by Chairman Brass. Any discussion on that? And all in favor of the amendment, raise your hand.
Talk about the sub, and the summary includes the amendment. Does that matter?
Yeah. Any opposed? All right. I'm getting advised by Legislative Counsel that your substitute already had this amendment. Is it different?
Not that I'm aware of.
Good. It is or is not different?
You need
So
to
it's already in
pass
there?
the bill with an amendment. And
You
then
see
just the
yours.
sub will report out.
Right.
Can we do that?
Yeah. All right, it comes out the same place then. So
Comes out the same place.
question on the table is now, your bill as amended, your committee sub as amended, which is really going to
Right.
be what you wanted.
That's right.
All in favor? Raise your hand. Any opposed? All right, the bill passes.
Thank you.
All right, at this time, I'm going to jump us one more as we're going down to Senate Bill 200. We've got a couple of witnesses that have time constraints. I have 5 people signed up to hear the bill. I'm carrying it. It's referred to as the Apex Doctrine, so I'm going to go to the witness chair, and I'm going to turn over the wheel to my very capable Vice Chairman, Senator Summers. Go easy on me now.
Where's the gavel?
We'll get to put the chairman on the witness stand.
Where'd my papers go? Right there. Here they are. All right, thank you.
No, that's right. Is that your sign-up sheet there too? For 200, yeah. And please, let's have a little good time now. Yeah. Is that a motion?
Motion to adjourn.
Not bad. Chairman Cowser, Senate Bill 200.
Mr. Chairman, I am working off of a committee sub that's been delivered to us today that just had a little cleanup language. I think everybody should have just been handed that.
Okay, thank you.
It's LC 365548S. Very minimal change.
Tell us about it.
So this bill addresses what is referred to as the apex doctrine. That's a legal doctrine, a legal theory that's applied in the course of discovery, which is preparation for trials. During the course of folks getting their cases prepared for trial, there are many occasions where they may take a deposition, which is a sworn statement under oath from various interested witnesses. This is addressed at allowing protective orders for very high-level government employees or officials and corporate officers. What we found sort of over the years is that sometimes people in those positions feel like they're harassed and intimidated, made to sit for depositions when they really don't have much personal knowledge on the issues they're being questioned about. For an example, if somebody claims they had a defective car and they're bringing a products liability case for injuries received in a wreck, they may want to take a deposition of the president of General Motors or Ford. Well, the likelihood of that individual having any personal knowledge of the design and functioning and testing of the vehicle are pretty low. A lot of states have either codifications of the rule or else have sort of court-made common law on how to deal with that. Georgia had a very interesting case that came up back, I guess, in the summer, and we're going to have some testimony on that case that sort of pointed out that Georgia did not have its own apex doctrine, certainly not enunciated clearly in the law, and so we have had some angst after that from the corporate community as to whether or not they're going to be subjected to these depositions, people that have no knowledge just to intimidate and harass them, try to bully them into a settlement in a case. So this tries to set forth a provision, doctrine, how we're going to deal with that in the state of Georgia, and you'll see we are amending a section of the Georgia Civil Practice Act, Section 91126, regarding protective orders. And it allows a person that is being requested to sit for a deposition to seek a protective order for that, or make a motion with the court accompanied by an affidavit that shows essentially that they don't have any unique personal knowledge of any matter relevant to the subject matter involved in the pending action. So that corporate official or high government official would simply say, listen, I don't have any information that you're seeking. There's nothing I'm going to be able to share with you in this deposition, so it's a waste of time here, and it's just harassment. Once that affidavit's filed with the court and made an motion, then the court should enter an order preventing that deposition, unless the other side, whoever is asking for that deposition, can show that they've exhausted other means of discovery to learn the same information, and that their other means are inadequate to gather or learn the information they're trying to seek, and that officer, the person they're wanting to depose, does have unique personal knowledge of one or more of the subject matters relevant to issues in the litigation. And then ultimately, at the end of the day, the officer seeking the protective order has the ultimate burden of proof of whether or not they are exempt from this. Now, that's a shorthand way of just giving a mechanism for a corporation when they're asked for one of their major officials to give a deposition to oppose it, explain that that person is not the appropriate person to give the information being sought, and to let the court give them protection so they're not harassed in this unnecessary way. It's pretty finite, pretty limited circumstances that this would be done, and I am going to request that Keith Blackwell be allowed to speak first, who sort of helped write this bill, and it was previously on the Georgia Supreme Court. He'll be on your list there, Mr. Chairman.
Yes,
You see that?
Mr. Black, will you come up, please? One there. There you go, thank you. Tell us who you are.
Good afternoon. I'm Keith Blackwell. I'm an attorney with Alston and Bird in Atlanta. I happen to represent General Motors in the case that the chairman was referring to. But I need to make clear I'm not here today to speak for the law firm or for General Motors or for any of our other businesses that Alston and Bird represents. I'm here today on behalf of Georgians for Lawsuit Reform. Georgians for Lawsuit Reform. It's an organization of business organizations in Georgia, companies in Georgia, including some of the most prominent companies in Georgia. And in fact, I'm joined here today by Will Barnett from the Home Depot and Emily Johnson from UPS. But it's an organization that's an affiliate of the Georgia Chamber of Commerce that's concerned about fairness and equity and efficiency in the civil justice arena.
Is that it?
I would like to make a few points about Senate Bill 200. I would urge the committee's favorable consideration of this legislation. I will point out that it would align Georgia's practice with what the practice is in all three of the federal district courts in Georgia. The Apex Doctrine is applied by the federal district courts for both the northern, middle, and southern districts of Georgia. It has been applied by the 11th Circuit Court of Appeals. It has been applied by the old 5th Circuit Court of Appeals, which formerly included Georgia. It would align practice in Georgia state courts with what the practice is in the federal courts of at least 33 other states. And it also would align Georgia state practice with the state practice in a number of other states, including states that are also like Georgia, large states and states with whom we compete when it comes to economic development. California has the Apex Doctrine, Texas has the Apex Doctrine, Michigan has it, and a number of other jurisdictions, including Alabama, has something that looks a lot like it. Indiana has something that looks a lot like it. This is a legal doctrine that's not universally adopted around the country, but has wide acceptance around the United States in a lot of jurisdictions. This particular bill tracks the rule in Florida very closely. The Florida Supreme Court, in Florida, their rules of civil procedure are not made by the legislature, they're made by the Florida Supreme Court. The Florida Supreme Court, I guess about 2 years ago, adopted a new rule of civil procedure to adopt the Apex Doctrine, and this bill, Senate Bill 200, tracks that language of the Florida rule very closely. It addresses something that Ms. Johnson and Mr. Barnett may speak more about, which is a real problem for high-level executives. They are prominent. They are public-facing. They often are targeted for depositions, even when they don't have any personal knowledge of the circumstances leading up to litigation. But it's not just the problem of giving one deposition. If I am the CEO of a manufacturer and I can be deposed notwithstanding that I don't have any personal knowledge about a particular product defect, if I can be deposed in that product liability case, I can be deposed in every product liability case against the company. And what you run into, and what a lot of the courts have recognized, is if you're a CEO or a high-ranking government officer, if you are subject to deposition in every single case in which your company or in which your agency is named as a defendant, you never get anything done. You wouldn't have time to run the company. You wouldn't have time to run the agency. So whether we're talking about the CEO or CFO of a large corporation, whether we're talking about Mr. Thurmond in DeKalb County government, whether we're talking about Sheriff Owens in Cobb County, whether we're talking about Mayor Dickens, or whether we're talking about the governor, they should not be subject to deposition in every single case in which the organization that they're running gets sued, especially when they don't have any unique personal knowledge of the facts and circumstances that led up to the deposition. I also want to make very clear, the Apex Doctrine has never been understood to be a rule that high-ranking officers just don't have to testify. It has never been understood in that way, and I don't think Senate Bill 200 would impose a rule like that. It is a rule that if you're a high-ranking officer and if you don't have any unique personal knowledge of any information that is within the scope of discovery in the case, you're not subject to deposition unless there's a good reason for it. And if the other, if the party that's wanting to take the deposition can come in and show, as the chairman said, that they have exhausted other means of discovery and there's just no other way to discover this that's less burdensome, then even then the deposition can go forward. But there are plenty of cases where high-ranking officers were personally involved in what led up to the litigation, and in those circumstances, it would not shield them from deposition at all, because they would have personal, unique knowledge of the facts that gave rise to the litigation. So again, I urge the committee to give favorable consideration to Senate Bill 200, and I would be happy to answer any questions that the committee has.
Questions, Mr. Byron? Anybody? Look, what is it, baby? 11?
Tell me what the apex doctrine is. I mean, if you involved with a major corporation, you got some knowledge of something going on. Even if somebody is suing you and you don't like the reason they're suing you, you know what is going on and what it's about.
Senator, that's exactly the difficulty that the apex doctrine is meant to address, is that high-level executives within these very, very large companies. I mean, I think you may hear from Mr. Barnett and Ms. Johnson about companies that employ hundreds of thousands of workers, and so there is no doubt that a CEO or a general counsel or a CFO, somebody in the very highest rank of the company, has some very generalized knowledge of all the company's operations. That's their job. They're supposed to exercise oversight over the company and help develop corporate strategy and policy. And so they have to know a little bit about an awful lot of things. And so that's the problem that it's meant to address, is their knowledge is not detailed typically. It's based on what other people in the company have reported to them, and sometimes what somebody on the line or in the field has reported to their supervisor, which is reported to their manager, which is reported to a vice president, which is in turn reported to the CEO. So it's kind of 5 layers of hearsay, if you will. If they were subject to deposition every time the company got sued, they do nothing but sit in depositions year-round. That's the problem that it's meant to address.
Something don't sound right about that. You know, I'm a little old late person, a little country boy, but something don't sound right when you tell me I'm involved with a corporation. If something happened down the line, I know something about it because somebody had to tell me about it and what the circumstances might be about what's going on in the company. And I would assume by you being a corporate executive, you have some knowledge of whether or not you're being sued for $500,000 or $1 billion, and what the circumstances are on the case, or whether or not we had an employee that didn't do what they were supposed to do that made this case liable for us.
Senator, if I could respond to that, I mean, that is a very good point, but it's something that Senate Bill 200, I think, addresses. I mean, let's take the CEO, for instance. Whether the CEO really is going to be aware of, for instance, litigation against the company, probably depends on the size of the company. If it's a medium-sized company, the CEO very well may be aware of every time the company's been sued. On the other hand, if it's the CEO of some multinational corporation that has 35 subsidiaries, they may have 5,000 cases pending against them in courts all around the United States at any particular time. Some of these companies have 300,000, 400,000, 500,000 employees under their corporate umbrella. They may have a substantial litigation docket, and the CEO isn't aware of probably 90% of that litigation that's going on. But this all comes down to, again, it doesn't just protect you from deposition because you're a high-ranking officer. It protects you from deposition if you're a high-ranking officer and if you lack unique personal knowledge of the facts in dispute. If you have that personal knowledge, And that would be quite common, I think, for small companies and medium-sized companies, for the highest-ranking executives to have some unique personal knowledge of the litigation. Then you testify. This rule and the Apex Doctrine doesn't shield you at all from deposition. It would only be when you lack that unique personal knowledge. And one example I give is, I live up in Cobb County. Sheriff Owens has, I think, about 500 sworn deputies under his command, and he has about 300 non-sworn employees in the sheriff's department, about 800 folks. There's probably a lot that happens in his department, although the buck stops with the sheriff. There's no doubt about that, and the sheriff's ultimately responsible for what happens with the department. I don't doubt that he can't possibly know everything that all 800 of those employees of the department are doing at all times, and he's not going to have personal knowledge about a lot of things that occur in the sheriff's department. That's very different than Sheriff Andy Taylor from the Andy Griffith Show, where it was just him and Barney. It was a two-man department. And so in that scenario, I doubt there was much that the Mayberry Sheriff's Department ever could have done that Andy Taylor wouldn't have personal, unique knowledge of. And so it is going to apply by its very nature less frequently when you're talking about smaller businesses, but even as to the largest businesses, it will not shield the CEO of the largest corporation from having to give a deposition if they in fact have some unique personal knowledge about one of the matters in dispute.
Surprise.
Start again.
Thank you, Mr. Chairman. Justice Blackwell, one question I'd ask is, when I look at this legislation, there would be somebody in those larger organizations that would be capable of settling lawsuits and handling the lawsuit. It's not to dodge the disposition of the lawsuit. It's basically just who's got peculiar knowledge of it.
That's exactly right, Senator. And in fact, if you're suing a company and you don't know who has knowledge, there's a way to figure that out. You can there are a variety of discovery mechanisms, but one of the things you can do if you don't know who can speak for the company is you send what lawyers call a 30B6 deposition notice, and you say, I want somebody, whether it's the CEO, whether it's somebody else, I want somebody who can speak for the company and bind the company by giving testimony on these topics, and you list out the topics, and then they have to produce somebody and make them available to sit for a deposition and answer your questions. That's right.
In the essence of time, Justice, if you'll just stand by here, I'm going to call up, if you will. You said Miss Emily Johnson, if she here, please. Miss Emily, would you please come up? Over here, if you don't mind. Got to get you to a mic. Just tell us who you are and what you're here with.
Sure. Good afternoon. My name is Emily Johnson. I am Senior Vice President and Deputy General Counsel at United Parcel Service, otherwise known as UPS. And I'm here to offer, on behalf of UPS, our support for the Senate Bill 200. UPS is headquartered in Georgia, as you may know, and our CEO and our 8 senior-most officers, which we call the executive leadership team, are also based here in Georgia, as are approximately 20 of our next highest level senior executives and officers. We do employ over 500,000 employees, so we are a very large corporation. Legislation is needed in this case to adopt a consistent standard for judges to apply when litigants seek to depose or conduct discovery involving executives and officers of Georgia companies for 2 primary reasons that Justice Blackwell touched on. The first is the potential for abusive discovery in lawsuits, and the second is the potential for an undue burden and distraction on executives with, and this is the most important part, comparatively little or no knowledge of relevant facts in the subject lawsuit. So more about the importance of deterring abusive discovery. So a lack of consistent framework would create a perverse incentive for litigants to do forum shopping in Georgia state courts and also seek depositions of corporate executives, not for the purpose of seeking relevant information, but rather for other purposes, such as pressuring companies to settle cases so that they can avoid getting their executives and officers bogged down in deposition preparation and deposition testimony. There are other witnesses that might have relevant information to the lawsuit in these cases. companies headquartered in Georgia are vulnerable because we very often are not able to remove cases for legal technical reasons, but we're not able to remove cases to federal court where the Apex Doctrine is routinely applied. The second reason I touched on is the importance of avoiding unwarranted distraction and burden on executives, given their little to no personal knowledge of information that's relevant to the lawsuits, and where they have alternative means, the litigants have alternative means of getting discovery of relevant information. As Justice Blackwell said, this is not a doctrine that has a purpose of avoiding relevant testimony by people who have personal knowledge. It's really to avoid bogging executives down who don't have personal knowledge of the facts at hand and where they can get relevant information from other means. Deposition preparation and deposition testimony, as a matter of fact, takes hours and hours of time. And if you multiply that by the number of lawsuits that could be filed against a company in the state of Georgia, as Justice Blackwell said, there really would be precious little time for executives to actually run the companies or organizations they're in charge of. They would have insufficient time and capacity to focus on things like managing risk and managing people and managing finances, liaising with the board of directors and shareholders and their customers, and generating income for their stakeholders. And that's just naming just a few of the vital executive responsibilities they have. Appreciate the opportunity to address you today and share our perspective on this issue, and thank you for your consideration. I will answer any questions you might have.
Questions? Sir,
At the
again?
appropriate time, I'm ready to make a motion.
Well, we've got a couple more people want to talk, so I'm sorry to tell you that. So
Beat the horse.
I hear you. Will Barnett, please. I don't have it on mic for you if you.
Can I ask a question?
Certainly.
In the interest of time, can we give the opposition
Right.
equal opportunity? But
Exactly.
We've had two people speak for it. Can we offer that?
Absolutely. You wanna
And
call
that way
it?
we can move on.
We have Dan Snipes with GTLA. Dan, will you take the podium?
Is that fair? Y'all agree?
Yeah, I think you're right. I apologize for that, Dan. Yes, sir, you're on, sir.
Yes, sir. I'm Dan Snipes. I'm the past president of Georgia Trial Lawyers Association. I practice law in Statesboro. I think it's important, and with apologies to Senator Kennedy, because I know he understands this, but I think it's appropriate for me to give some background that Georgia has statutes that already describe what's the appropriate scope of discovery, and that's in 91126B1, and then there's, B2, and there's also a statute, though, that already allows for objections to discovery through moving for a protective order that already does not allow for depositions to move forward or other discovery to move forward if it's oppressive, burdensome, if it's just too much. If it outweighs the relevance of the discovery, 91126C already has a mechanism in place that doesn't allow the kind of discovery that Justice Black was talking about. Now, when he talks about the federal courts and there being a federal standard that deals with Apex, you have to understand that there's a different federal scope of discovery under Federal Rule of Civil Procedure 26 versus what Georgia's scope of discovery is in 91126. So any comparison between a federal Apex doctrine and what Georgia has does not recognize the fact that Georgia has a broader scope of discovery than the Federal Rules of Civil Procedure. So that's not an apples and apples comparison to say that federal courts recognize this doctrine, because there are different rules they play under. Now, from us looking at this, there are two states that have passed this by statute, Florida and Virginia. There's somewhere between 5 and 10 that have passed this type of legislation through various types of case law. The Georgia Supreme Court, in the decision Buchanan versus General Motors, issued an opinion in June of 2022 that dealt with when the CEO of General Motors could be deposed in a case involving trailblazers. Now, the CEO in that case had been involved in a program about Speak Up for Safety, and that actually dealt with a potential recall of trailblazers that was not done. And in that case, where the Supreme Court allowed her deposition to go forward, she was involved in a program about the product at issue in that case. But it's not being completely above board about everything to come in and try to compare this to every other state, because Georgia doesn't have a problem with this. This is a solution looking for a problem. With the bill before you, SB 200, Importantly, the line 50 of that bill, where it has burden shifting. And what it says is, if the party that wants a protective order, the movement, the party that's coming into court saying we want relief, it says that the burden would shift in this circumstance to the respondent. And in the Georgia Civil Practice Act, the movement is the party that has the burden. This statute would change that by filing a motion and attaching an affidavit, it would shift the burden to the party that wants the discovery. And that's not how motions to compel work. If I want discovery and you object to it, and then you don't give it to me, and I go to the court and say I'm entitled to it, I've got the burden of proof. The party who's asking the court for relief is the party that has the burden, and this statute would change that. The Georgia Supreme Court in the Buchanan decision did a really good job of trying to strike a balance between what the scope of discovery is. But in Georgia, it doesn't matter whether you're the governor or you're the CEO of Home Depot or the CEO of UPS, or if you're just a small town mom and pop guy in Statesboro that's got a store. You're not above discovery. You're not above the process of law. And what the Buchanan case said is we've got to weigh that out. And you've got to look at unique knowledge. And you've got to look at, do you know something? But that's already in the law of you have to have relevant information under 911-26B. And then we got to weigh that against whether or not it's oppressive or burdensome or not needed. And that's already there under 911-26C. GTLA takes this position, though. For somebody like the CEO of a GM or Home Depot or UPS, depositions of top-level executives should be rare, and they should be very limited. But this bill creates a burden shifting mechanism that would make them almost impossible. And what it's doing is saying that if a citizen needs to take that deposition, we're putting another group of citizens above them in the eyes of the law. And that's just not what we need to do. GTLA and Dan Snipes would ask you to vote do not pass. Thank you.
Dave, may I ask you a question while you're there?
Yes, sir.
Every non-lawyer understood everything you said, okay? We got
I
that.
tried.
I mean, you did a good job. What's the deal? Is there some kind of House bill? What's the deal with 530? What's that? Is that part of your deal?
We have been working with Mr. Blackwell and Georgia for Lawsuits Reform on a compromise bill. House Bill 530. That bill passed House Judiciary today, is in House Rules Committee now. We're still working out some details, but in that bill, we've ironed out a framework, which is a different framework than Senate Bill 200, and a place where I think we can find common ground, I hope.
Thank you. That sounds good. Guys, we're getting short on time here. We've got another committee coming in behind us. Any questions for Dan? Any questions for Sipes? Anybody? Okay.
Thank you.
Ma'am, I'm sorry. Oh.
Said I'm clear.
Okay. I got one more.
Thank you, Mr. Chairman. Will Barnett for the Home Depot. I will just be very brief and say the Home Depot does view this as a problem. We do view it needs, the Apex Doctrine needs protection in the state. We are fully supportive of the bill before the committee, and I fully endorse my fellow witness's testimony. This is an issue that comes up frequently in the cases I manage at the Home Depot, and companies here need this protection. Thank you. Happy to answer any questions.
Any question for these people? Chairman Brass.
Is this what it feels like to be on a jury?
I'm beginning to wonder if it's supposed to feel like to be a judge. Not sure. All right, boys, committee members, we need to make a motion. I need a motion here, or will the committee, what we want to do with it?
I got called in, but I need to judge.
We have a motion from Senator Ginn to do pass Senate Bill 200 as substitute. Do I have a second?
Second.
I have a second from Senator Gooch. All in favor of the motion, please raise your hand. 1, 2, 3, 4, 5, 6. We have 6 for it. All those against the motion? 1, 2, 3, 4. Motion
You had 7 for it. You didn't count Senator Kemp.
Oh, I'm sorry. My apologies. You were on the witness stand. I apologize. Thank you. Motion passed. You want to, Senator Kaiser, while you're there, you want to try to quickly attack Senate Bill 172?
He ain't gonna give it up. That's 172. Oh, snaps. Let's do it.
Get what you ain't got
Preacher.
anyway.
Mark, here it is. Here we go.
I'm sorry.
You didn't want to have to break that tie, did you, Card?
Yeah. Amen. All right, guys, we're still jumping around the agenda just a little bit. We're going right back. Let Senator Cowser finish up there. Chairman Cowser, Senate Bill 172.
This one again is working off substitute. It's LC 550049S. We've had a couple of discussions in this committee, really over the years, as this is the third version of a sports betting bill that's been before this committee. There's been one every 2 years since the United States Supreme Court decision that allowed states to legalize sports gambling. You were all present when we passed the constitutional amendment, Senate Resolution 140, that goes along with this on Thursday of last week, and we've had numerous discussions. But briefly, it allows creates a Georgia Gaming Corporation to license and regulate sports betting. It gives a series of licenses that are in different levels. One is essentially, the bookmaker. We call that a type 1 license. We guarantee that our lottery board can get one of those licenses. If the Georgia Lottery wants to present and propose sports betting to its customers, it's allowed to do that. At least 5 others, so there'll be a total of 6 at a minimum, but really no limit on the number of type 1 licenses that are the bookmaker type licenses. It also sets up a system for a type 2 license, which are retail licenses, and these are the little kiosk machines, if you've ever seen them in a casino, where you can place your bet in a machine. It's still wired online, but it's just another terminal essentially to do that. And this bill limits those to no more than 2 per retail location. Does not allow the use of co-am machines for accepting sports bets. There's some pretty state-of-the-art things in this bill, but the basic structure is you have a gaming corporation. It would have 3 members appointed by the governor, would have 2 members appointed by the Speaker of the House, and 2 members appointed by the President of the Senate. So those 7 people would then be the gaming corporation, and they would serve as the sports betting commission and would elect a director or hire a director to run the operation and all the regulations. There's some things I wanted to point out in this bill that I think are important for you to know about. One is the tax rate. It sets the tax rate, generally speaking, at 20% on bets, but it allows it to go up to 25% on the certain high profitability bets that are very profitable to the gambling operators. This would be on page 39 in your sub. Lines 962 is where we discuss, starting there through 968, the tax rates. It's important in this bill that the taxes are based on the adjusted gross income of the corporations, or whoever's offering the bets. And we define adjusted gross to essentially be the bets placed, the amount of bets placed minus the winnings paid out. So a business is not allowed to deduct their managing expenses, their advertising expenses, and their incentives that they make minors to place bets and to solve problem gaming. It has many provisions in here that are designed to prevent people from getting into financial trouble from sports betting. We heard the presentations the other day about how addictive it can be, and that a certain percent, maybe 1 to 3 anyway, of people that participate in sports betting end up having either compulsive gaming or addictive gambling problems, and those are very difficult to treat. The young people are especially susceptible to them, so this bill prevents anybody under 21 from placing a bet. It also prevents advertising to that demographic. If you would take a a look starting at page 17, there are some very, down there at the bottom, 420, some very precise and what I call them is state-of-the-art provisions to try to protect against problem gaming. And you'll see under the little subparagraph 13 that the commission is to establish and administer programs to give assistance to compulsive or problem gamblers, and it lists all the way here, A through I, the different types of programs they should do. Everything from educating the gamblers as to the likelihood of winning, the type of games that they're playing, the likelihood of developing problems, how to prevent against problem gaming. It also encourages harm minimizing measures, and these include self-limiting yourself from betting, to tell the betting platforms, I do not want to bet more than $500 this weekend, or whatever the number may be. There are also rules and regulations to allow people to cool off from betting, to stop, take a break if they're exhibiting signs of problem gaming, and to warn them of these. And also processes for them to call to get help, to express concerns, to talk to a counselor if they are beginning to be concerned that they may have a problem. It goes so far as to even allow the commission to have rules that can regulate or stop the amount of money people are betting if they have exceeded their limits or if they are exhibiting problem betting. There are more provisions on the problem betting deeper in the bill. If you go to page 49, there's some specific duties put on the licensee, the people that are offering the bets. Those rules and regulations I was talking about are for the commission to establish for everybody to follow, but they are very other specific rules and regulations that are going to apply to the licensees for them to provide these services, to warn people about problems, to let them know if they have a situation developing, to allow them to self-limit, and for us to limit them if need be, if they're having problem gaming. Another unique provision in this bill is at the bottom of page 47, starting at line 1165. This creates a system where bettors are not allowed to deposit into their accounts more than $2,000 per month. And they might limit themselves to less than that under certain circumstances, but it gives a provision that if they can demonstrate their financial ability to absorb higher losses through higher income or assets, that there can be rules or regulations we'll defer to the commission to set to allow them to play more than $2,000 per month. I came up with that number because that is a little bit less than 50% of our median income in the state of Georgia, which is roughly $50,000 per year for the average Georgia family. So if you're betting $24,000 a year, that's a pretty hefty share of your income, really higher than I'm comfortable with. Could cut it off before that. Anybody making their deposits into their accounts cannot use credit. Cannot borrow money to do it, can't use a credit card. You got to either make a to be an asset that you have. Don't go borrow money to place these bets. That's another additional type of protection. One other very unique thing in this, and this comes from really suggestions from the University of Georgia, is that it eliminates or prohibits taking a proposition bet on a college sporting event. A proposition bet, it's defined in the bill as when you're betting on something other than the outcome of the game, something determined by the play. Examples would be the number of receiving yards that a person might get, the number of field goals a team might score, whether you have an interception, if it's returned for a touchdown, anything about the individual play, individual statistics rather than the final outcome. The pressures this would put on a college athlete when they know that there are gamblers betting on their performance are enormous. And you can imagine how a kid feels when they miss a field goal to lose a football game. Or what if that also is impacting the number of field goals kicked in the game, et cetera, or if a quarterback throws an interception. It creates a temptation or a possibility for players to they used to call it shave points in basketball back in the day, but to impact the outcome of their play to affect bets on the game. And that is a dangerous circumstance to have. That does not apply to professional sports here. They've been taking those kind of bets for years, and those players are played for their performance, et cetera. It's less likely that they would be engaging in anything illegal, or that they would be subjected to the same type of pressures. As far as the license fees, that's laid out here on the Type 1 licenses. It's $100,000 to apply, and it's $1 million per year to be licensed as a Type 1 licensee. On a Type 2 licensee, the retail license for somebody in the store that wants a couple of these kiosks, you can't have more than two. It's a $500 application fee and $1,000 a year per machine that you would have. I can go into more detail. I understand we've got a shortage of time, and I just would say that this is in my opinion, a well thought out mechanism for offering it that's highly regulated, that protects young people, protects us from preying on vulnerable and poor people, and protects against problem gaming. I'm happy to answer any questions that you may have.
Say it again.
Thank you, Mr. Chairman. When you touched on the percentages that would go to the state, the 20 to 25%, what did you come up with that? How'd you derive that number?
I've studied every state, what the rates are, and they're anywhere from 7% in Nevada to 51% in New York. In the state of Georgia, our lottery is by law required to generate 35% profit.
They've never done it.
They've never done it. At one point, they were down 23 or 4%. They've now gotten it up closer to 27. So I wanted this to be competitive with that, so they're not cannibalizing their own sales. I have a different view than some people as to what the income level would be. I think it's more than likely going to be close to $50 million per year generated from this, and that would be at the 20% rate for most bets and 25% for those exotic type bets.
I get you. Senator Albers and Senator Luke.
Thank you, Mr. Chairman. Mr. Chairman, thank you first off for the incredible work. You have studied this issue probably more than any senator in any state. Quick question for you. For the kiosks, I always think of sports betting as people using their mobile devices. Is this in addition to mobile devices?
It is, and they're all wired. I mean, these are all electronic forms. It's just think of a kiosk as a computer terminal.
Okay.
You know, you could place these sports bet on your laptop at home, or at your desktop at the office, on your mobile device, which gives you access, or a kiosk which is giving you internet access to that betting platform. That's all it's doing, is allowing you to place the bet through that terminal rather than the terminal that's your phone.
So just one follow-up question, if I could. What would be the difference if they went to the public library that had a couple of computers that had high-speed internet access? Would they just be able to use that computer and still have access?
They could.
Okay, thank you.
You have to be within the state of Georgia, and we can geo-fence it, but if that library is in the state of Georgia, a person could make a bet there. I left out one thing you reminded me of, and I think this is unique how we can use technology now. In order to be a gambler, a bettor, to place a bet in the state of Georgia, this requires you to register and create an account with the gaming corporation. You would also have an account with a unique account number with each of many possible platforms. You might want to play MGM bets, win bets. I don't know who all else is offering this, DraftKings or whatever, but each of them would have to be reporting your play to your account, so that if you exhibited signs of problem gaming, you would be flagged and they would warn you. And they can send you a text message, say, warning, you're exhibiting signs, and also can find if there are irregular betting patterns that might indicate a game had been fixed or somebody was doing something inappropriate. It allows that to be tracked very easily.
Senator Lucas.
Senator, where in here does it, in this enabling legislation, that puts $250,000 of the Sports Hall of Fame?
That would be in the budget. In the constitutional amendment is where we dedicated the funding, and there was 5% dedicated to the promotion of sports, the solicitation of events that are both state, national, regional, or international, and that's the authorization for that. It creates a trust fund so that 5% of these benefits will go in there, and then that would be allocated in the budget up to where you're talking about $250,000 a year for your Sports Hall of Fame.
The question I have is, how do you get it there? If it's in there, I want to see it in there, and that it can only be changed by the General Assembly. So how do you put the $250,000 in the Sports Hall of Fame? It's a state Hall of Fame.
In the state budget. And this sets forth a fund that may be used for that. So you're not needing the governor to give you a revenue estimate. It's the amount of money that's earned through these, they call them a privilege fee, privilege tax here. A percentage of it goes into a trust fund, and the legislature directs where that goes.
All right, so, I mean, how do I get the $250 to the Sports Hall of Fame? That's what I want to see. I passed the bill that went through the Senate, the House, and got vetoed. I want to make sure it gets there. So how do I make sure it gets there through this legislative process?
Well, the budgeting process is the same no matter what. This just gives you a fund of money to appropriate for what you want it to go to. And this keeps this money from being snagged and taken to go pay for anything else, public safety, or pick another government service that we do, building a road or whatever. It can't be used for anything other than these sports, that 5%. Then you have to get it in the budget process to go there.
It wouldn't be a line, it'd be automatics.
Senator Brass.
Thank you, Mr. Chairman. Couple questions, series of questions, if you don't mind, Mr. Chairman. One, on the different licenses, you got type 1, type 2. Are we limiting, I know the type 1 was specific for the lottery, is that correct?
No, that's not. One is guaranteed for the lottery.
One is guaranteed. Type 1?
One type 1 is
Okay.
guaranteed to the lottery.
Are we?
And at least 5 others, but no cap.
There is no cap.
No
Okay,
cap.
that's first question. All right, second, I want to go into around, starting at line 265, where we're creating the Georgia Gaming Corporation.
Yes.
And then if you flip over, so we're going to have the Georgia Gaming Corporation, and then is the Georgia Sports Betting Commission going to fall under the corporation?
It is. And it will be the same individuals.
It will be the same individuals. Okay.
So the corporation, it's just like the lottery corporation. It will basically hire or elect a director, and that person will be the same thing, director of the Georgia Sports Betting Commission and the Georgia Gaming Corporation. This is a structure that could be expanded in the future, theoretically. You could have a Georgia Sports Racing Commission that would also be under the corporation, and a Georgia Casino Corporation or Commission if the voters of the state wanted to go there one day.
Okay. All right, that's my questions. Thank you.
Sure.
In the essence of time, we got several people that signed up right quick. Like, guys, I'm going to have to give you a couple of minutes here. If Professor John, I can't read the last name. Kent, I'm sorry. Kindergarten, all right. Please take the podium right there. I might have to limit you on time. I apologize, we're running short. So please try to get it quickly.
Professor John Kent, for over 3 decades, my colleagues and I have taught, published law, economics, and business studies on gambling issues, including Emory, Mercer, UGA, and other Tier 1 universities. My colleagues and I take no consultant fees or honoraria for working on gambling issues. Hundreds of academic reports condemn what you're about to do. This is just one volume of a multi-volume set, and as a matter of fact, this particular volume is dedicated to Dean Rusk. We had 5 years of testimony on this, and the U.S. National Gambling Impact Study Commission, 5 years of testimony. Geofencing doesn't work. The sports gambling regulations are not going to work. Kids are hacking the Pentagon. It's not going to work. All of these reports say it's not going to work. There is a backlash that's getting ready to occur. I'm a little distressed that we only get 2 or 3 minutes each here to discuss this. the exact same arguments. My colleagues and I testified under oath before Congress and multiple state legislatures all across the country. You hear the exact same arguments for let's legalize crack cocaine. Let's legalize heroin. I've got 13 grandchildren. They're asking me how to place bets. You know what grandchildren are? They're God's gift for not killing your children. But I want to protect my grandchildren. They're all here in Georgia. And all the medical community knows that sports gambling, electronic gambling, is the crack cocaine of creating new addicted gamblers. Kids are vulnerable to this. They can hack into this. I appreciate the good faith efforts of the chair. He's obviously done a lot of research and a lot of work on this, but the same arguments can be made for legalizing hard drugs. And my 13 grandchildren, I'm sorry, are worth more than $50 million. Are your children and grandchildren worth more than just pennies of $50 million bucks? And how much are you going to spend to address the problems? Well, we have multiple documents in here, studies from Emory in particular, that says that that for every $1 you're bringing in, the costs, the social and economic costs, are going to be $3 to $7 to $12. And minorities are being targeted. Minorities are already showing double the gambling addiction rate of the Caucasian population. I actually submitted several things here to show on the screen. One was Jesse Jackson on Martin Luther King Day in Chicago saying that this gambling expansion are the new economic chains of involuntary servitude. And he was much more dramatic than that. This targeting of kids, minorities, has got to stop. You can't. I appreciate what the chair has done here, and he's obviously trying, but the academics, hundreds of reports, all republished here, it doesn't work. You can't control this. It's soon going to get out of hand. Once you start down this road, and this has happened in state after state after state, and I've heard all of the prohibitions that have been put in place, they've all fallen by the wayside. So I ask you to not approve this. Save our kids. This is about kids, the next generation. Who cares about $50 million? And by the way, if you read the Wall Street Journal from Super Bowl weekend, it says that millions of people are already being scammed and cheated. Check it out, Super Bowl weekend, Wall Street Journal. Why? Because these regulations don't work. Thank you.
Thank you, Mr. Kent. Mike Griffin, is that right? Mike.
Yes, sir. I'll defer to anyone else. Of course, Georgia Baptists oppose gambling in this legislation, but I'll defer to anyone else who'd like to speak as well. Thank you.
Is it Mac Passell? Is that saying it right?
Mac Parnell, Executive Director.
Parnell, you got it right better than that, Mac.
Thank you. I appreciate that. Mac Parnell, Executive Director of the Georgia Faith and Freedom Coalition. Georgia Faith and Freedom Coalition is opposed to this legislation. Thank you.
All right, we're moving good here. Brianna Doria. There she is. Come on up, grab that microphone. Tell us who you're with.
The National Council on Problem Gambling. We'd like to commend the senator for doing his due diligence of all the sports wagering legislation that's currently being discussed in this building right now. This is the only one with funding for problem gambling services. Right now, Georgia has systemically failed to protect and offer treatment for the 115,000 individuals who are currently struggling and those that will struggle in the future. This bill would also remedy some of those shortcomings addressing funding. We've never seen in the 36 states, DC and Puerto Rico, when they've discussed the legalization of sports wagering, to have so many things accounting for the education, the prevention, the treatment and recovery services for anyone who may struggle. I'm happy to answer any and all questions about the U.S. sports wagering, problem gambling, but we really do commend the senator for his efforts here.
So you're good with this?
We're neutral in legalized gambling. We're very supportive.
Neutral, can't be neutral, gotta be, no. Just gotta-
Thank you.
Thank you very much. David Fadol, is it David?
Hey, good evening, everybody. My name's David Fadul. I'm a concerned citizen from Cobb County, and I'd just like to bring morality into the conversation right now. I mean, are we considering the impacts that this will have on culture right here in Georgia and beyond? Are we considering the degradation effects that it'll have on these people? The emptiness that it'll leave them? Empty in their pockets? Empty families? Empty in spirit? Are we considering that at all right here? Or are we trying to build up culture? Are we trying to tell kids, hey, there's a way to go out there and make money more than a quick come up? We're not doing it on instant gratification. And that's essentially what this bill proposes, which is why I'm vehemently against it. So I would implore all of you to please carefully consider this. Thank you all very much.
Thank you, sir. Anybody questions for Senator Cowles? You want to close this out?
I think we
Ready to go?
pretty much well covered it, yeah.
Guys, we got a bill before you. What's the will of the committee? Do pass. Got a motion to do pass. Got a second. Doc, Senator Doc over here. Okay, everybody in favor of passing this legislation on the rules, raise your hand. Anybody, all those opposed? One against. Senator Cowser.
Thank you. Where's my phone?
That's your phone. This is yours.
Yeah, I'm looking for my phone. I'm looking for my phone.
Oh. Look at your phone. You got mine. Oh, sorry.
All right. Fortunately, I got 6:02 here, and we're losing our quorum quickly. Who we got left?
You got
We all think it.
right here, baby.
You got Chuck right.
Chuck.
Chairman Huffstetler, I'm going to give you time to present your bill, Senate Bill 163. I'm not positive we're going to have time to hear everybody on it.
Thank you, Mr. Chairman. Turn my mic on there. I appreciate it. As you may have seen from Kyle Wingfield and his article on this, and the first person that started deregulating the beer brewing was Jimmy Carter back in 1978. But I'm trying to get Georgia to be more competitive with North Carolina by allowing those facilities to donate their product, and they would still pay the taxes, to allow them to self-distribute in a radius around their business. And this would be for 3,000 barrels. North Carolina does this with 50,000 barrels that they could get out of a distributor contract in 30 days. Again, similar to other states that are doing this, and that there not be a daily maximum put on them, even though there is a 6,000 barrel limit, there would be no daily maximum. We've got, don't have time to go over all the states, so I'll just pick North Carolina, but a state with a slightly smaller population has a much more robust market, doing almost double what Georgia's doing. These brewers are not asking for a tax credit. They're not asking for a handout. They want to pay their taxes. They want to pay more taxes by selling more product. They just want a free market and some competition to be able to sell a little bit of product from their brewery.
Senator, if I understand you correctly, basically what you're saying is you're sort of separating the distributors from the brewing company, where they have more choice, I guess is what I'm trying to say.
They're allowed to, within a radius of their business, self-distribute up to 3,000 barrels in a year. In North Carolina, the same thing is 50,000 barrels. They need to be able to to push their product a little bit. That's why North Carolina does way more business in this area, is there's not a free market.
Other questions? Senator again.
Hey, thank you, Mr. Chairman. Hey, when I look on line 75, you talk about that radius, and currently you have it listed as 100 miles. That's a long way for.
I would be open to a different number.
I'd suggest that we move that to 5 miles, because most of these breweries are local, small. You know, hey, they want to serve their community, little small town, something like that, and that'd take care of most of these small towns. So,
Well, I don't think you could get to, you know, the end of some of my counties where they service in 5 miles, but
we're not in the distribution business. We're in the brewery business.
But like North Carolina, they want to market their product, and again, it
That's
limits
North
it to
Carolina.
just.
We don't want to. We
it's
don't
just-
give those people an advantage.
Well, we want to have a free market here, and we don't.
Senator Summers, you have a question?
What do you, yes, sir, thank you, Mr. Chairman. Senator Hufstadter, what do you think's a fair miles? 20 miles, 10 miles? What do you think?
Well, I wouldn't want to see it less than 25 for sure, if we could do that. I think that's pretty small. I'm not sure that would cover them, but it might get, 25 miles is pretty close. Those guys can cover more than that.
Do we have anybody else signed up to speak on the bill? Martin Smith, if you'll come on up.
Thank you, Mr. Chairman. I'm Martin Smith. I'm the Executive Director of the Georgia Beer Wholesalers Association, and there's a lot of information that goes around about the relationships between the brewers in Georgia and the wholesalers, the distributors, and the retailers. I think it's very important to make it clear there's not an opposing side to this. The brewers of all sizes in Georgia and the distributors in Georgia are strategic partners. And that's not just by saying we support their products or we have to work with them or anything like that. There is a rule or a law that requires, yes, a brewer, when they have a product, to assign that product to a distributor. That brewer decides what county those are going to be distributed in, who's going to distribute it, and they do that. The second part that takes place between this partnership is a unsecured financial investment that the only way to have a return on it is by that product being sold and making money. Our guys invest directly with these brewer partners that they have in ways that they are going to market the product, the cooperage, to the transportation, all these things that they're committed to, that we're committed to doing financially. And we put that money up front to do that in each of these cases. So as we are purchasing these products from our brewer partners, not only are we purchasing at that time, but we need it to sell, and we're incentivized to do that. So when I talk about a partnership, that's the type of partnership I'm talking about. This bill, as it's described, does a number of things. Senator Hufstadter addressed some of those things. One of the things it does, and we need to understand, is in Georgia, we're the 5th largest producer of beer in the nation. And that's made up of, we've got the 2 largest brewers in the world that are here. You've got Anheuser-Busch in Cartersville. You've got Miller Coors down in Albany. We've got some of the largest craft-style brewers here in the state, whether that's Sweetwater or Terrapin or Monday Night Brewing. All of them have been very successful, and you've got ones that may have just opened yesterday. What his bill proposes to do is to give, based upon the annual sales of a wholesaler, based upon those annual sales, would give any of their supplier or brewer partners who represent less than 15% of their portfolio for that annual year, for that year, calendar year, to be able to go self-distribute and move their products away. 15% sounds like a pretty small number. I called each of my members just to see what part of your portfolio exceeds, which brands exceed 15%. One of my biggest members happens to be, they distribute Miller Coors, which is a Georgia product. Miller Coors doesn't even represent 15% of their market, of their total. Some of the other ones that y'all each know, that maybe carry Anheuser-Busch, another big one here in Georgia, it barely gets over 15%. The rest of them, which is the entire portfolio, represent small portions of percentages. Our entire portfolio, we represent this type of niche for the entire process. So what's been proposed in here is not an innocent thing. Every supplier will be gone. It would allow for every supplier to be self-distributed. Every one of them. Be done. The wholesale business three-tier system would be kaput, done. So to that point, that makes no sense to me. How is that an innocent thing? It also allows for the franchise change of them being able to, without cause, to, in the bill, if you read it, it says the agreements. Well, the agreements are secondary to the brand assignment. I think what the author probably meant was the brand assignment, but that's not what's in here. But nonetheless, brands are signed, according to the Department of Revenue, and I see it every day, nobody wants to keep somebody hostage if they're not happy in their situation. Brands are released and reassigned on an average of twice a week, all day, every day. So that's already happening. The charitable contributions. It seems nice. It's like, let's give some, this was last year's bill also on the charitable contributions. If there's your local junior league and they're going to have an event and they want to have some beer there, there's two ways they can do it. They can go to the store and buy some beer. And if somebody in the community wants to write them a check, great. If they want to buy from a wholesaler or get it from someone, they can go get a special event license from their local city or county, then get their state license, and that turns them into a temporary retailer, a licensed retailer, just like Kroger or Publix. At that time, they are allowed we're, as a wholesaler, able to provide product to them because they are a licensed retailer. We can give it to them for free. We can go pick up the remaining part of it, and the way it always works is our brewer partners may call and say, hey, this event's going on in the community, we want to do it. You've already got the product in your warehouse, send them 30 cases over there, and we'll figure it out on the back end. We'll either write you a check or we'll give you a credit for that product, whatever, for the next one. So it gets done, the taxes are done correctly, and as appropriate for the three-tier system, the distributor's dealing with the licensed retailer, not the supplier or brewer. So we have no issue with charitable stuff. It's dealing with licensed retailers in this process. So it works today. The concern is let that process work. If you allow the supplier to deal with, even if it's a temporary retailer, charitable or not, it breaks that structure. Then another part of the bill is to eliminate the off-site sales, meaning today you can go into a tap room and you can belly up to the bar and you can drink up to 6,000 barrels of beer a year. 6,000 barrels of beer a year is 2 million 12-ounce bottles. That's 68,000 cases of beer. That's more than any of Walmart's in your town sell in a year. They have the ability today to sell that out. They want to eliminate the case per person per day and turn themselves eligible to be the #1 retailers in the state overnight, competing with all the other retailers. Some of the comments, that's what the bill proposes, but some of the comments that were made by the chairman a minute ago about competing with North Carolina. Georgia produces the second most craft beer. Forget Anheuser-Busch and Miller Coors. Second most craft beer in the Southeast, only North Carolina. He says we're way behind them. North Carolina did 482,000 barrels of beer, where we did 452,000. So I don't think we're that far off. It's nowhere near half, the percentage-wise there, so it's not accurate. And since 2015, there's been a number of instances where the legislature has felt that the need to address some of the concerns in our industry, and we've played a vital role in participating in that with our partners. Most of those things are not the items in here, in this wish list that's been put together that shows where this mission is going. We heard mission creep multiple times. We know what the mission is now because it's on this paper, black and white. It may be incremental steps to it that we've said no to, but if you look, starting back in 15, just in short time, created the tap room model for brewers to be able to have people come in and taste their product. In 17, 2 years later, Senate Bill 85 allowed them to sell 3,000 barrels of their product direct to consumers in there, whether that's belling up at the bar or having a case per person to go that day. And at that time, they were saying, we don't want to be retailers. We don't want to compete. We want people to come in and taste and learn about our product, taste it, buy some to go home, and the next time go to the store and buy it. 2021, we worked on the transfer bills. It was very important. It's an industry issue. We helped figure that out. Y'all led the charge on it. Addressed it, and at that time, not only were they able to do the transfer and address it, doubled the capacity from 3,000 to 6,000. So I say that to show that we're willing to work on all these things, and all of those things have improved our industry. It's gone, one last thing is, from 15 to 21, we've gone from 45 brewers in Georgia to 155. The system is working.
Thank you. I was in a time jam here. Senator Kennedy just got called to ethics, and I'm being called to have a quorum, but I want, it's only fair to let somebody from the craft brewery side be heard. I know that Nathan Cowan's made some effort to be here. Eventide Brewing, is that, if I got you?
It's Eventide.
Eventide.
But close enough. We get Eventide, Eventide, all kinds of crazy. Do I have time to speak?
I'm gonna make time for you to speak. They're just gonna have to wait on me. I didn't maybe quite comprehend how many people wanted to be heard on this and how complex
I think
this issue is.
our entire industry would like to be heard on.
Yeah. Okay. Well, let's just hear from you for now, and then we'll have to have a further hearing on it.
Okay.
Thank you for making the effort to be here.
I do appreciate y'all taking the time and giving me a minute to speak. My name is Nathan Cowan. I'm with Eventide Brewing. I've been the CEO there for going on 10 years. We're in Grant Park, right over the hill here, little neighborhood. Obviously, I'm here to advocate for you guys to support this bill, the Fair and Open Access to Market bill. It does mean a lot for a small producer of beer. And what I mean by that is somebody that makes, that is somebody of our size, somebody that's not of the Terrapin or the Sweetwater or the Anheuser-Busch or Miller Coors size. Right now, the way the system's structured, having to go through the three-tier system, having to go through wholesalers, really the barrier to entry is you have to produce somewhere around 20 to 30,000 cases of a product in order for that product to be financially viable in the market. Meaning, in order for us to get a return off of a product, we have to put out somewhere in the neighborhood of about 30,000 cases of a product. And that's a lot of product to put financial backing behind and develop and to flesh out without being able to ever take it to market. Well, does a consumer like this product? Does the pizza joint across the street, are they selling it well? We get a little bit of feedback from the taste room, but that's kind of a real cross section of the population. A lot of times it's tourism. That's where the one case per day doesn't make a lot of sense. We have 19 different styles of beer. So if somebody was driving back to Florida and they wanted to take 1 6-pack of everything, they couldn't do it. They could pick 4. Kind of as a counterpart to that, we have 19 different styles of beer on the wall every day. We have 3 styles of beer in the market right now with the wholesaler. On that front, if you do have a product and you have to make 30,000 cases of it in order to be profitable off of it, and you have to put a big investment behind it in order to even bring it to market. If the distributor says, hey, no, we don't want that product, there's no recourse. You can't take that product to another distributor. You can't take that product to market for yourself. You can sell as much of it as you can out of the tasting room, thank goodness. But other than that, the rest of it's got to go down the drain. That's a large cost for a small brewery. For a small business, it's a large cost for a small brewery for sure.
Explain that to me again one time. You can't.
And it's a little deeper than that. So if I have a product, if I sell 1 case of beer to a distributor, that distributor owns me lock, stock, and barrel for the rest of my life. So 10 years from now, I might not even be working there. Whole new brewery, whole new brewer, same brand. They already own the rights to the beer. To the beer. I can't go to market in any other channel other than that distributor.
That's because you selected that
That's because state law says if I sell 1 case of beer through them, it has to be registered via the DOR, right? So if I sell 1 case of beer, they essentially own, I can't register any brands to any other distributor ever. unless they give me an authorization of release. We just switched distributors last year. That downtime and the cost of switching cost us somewhere in the neighborhood of $250,000. So yes, it can be done. You can bounce around. It's very expensive to do so. Probably going to sink our company, but it can be done. But all that is to say, the real problem with craft beer in Georgia is we have such a barrier to entry. It's a difficult state to develop a product in and to vet whether or not that product's viable for the market, for distribution. That's not saying that the distributors don't provide a valuable service. I mean, if you were going to make 30,000 barrels of a beer, that would put you more in the distribution company, in the distribution business, than it would be in the manufacturing business. And at that point, or even well before that point, you would be rather crazy not to engage with a distribution company. All this bill is saying is allow small breweries to have better opportunity to make that bottom dollar so that they can be solvent as a company. They can invest that money back in their community. They can invest it in their operation for making better quality beer. They can invest it in their salaries for their employees. Just essentially allow for them to be a more viable company. And then if there's a win, if they get a win, if they get a beer that everybody likes, that does well in the market, there's distributors out there that can help put that product from every corner of the state to every other corner of the state, whether it's a pizza joint across the street or if it's a pizza joint in Savannah, Georgia. And that's really what this bill allows for. As far as for the charitable contributions aspect of it, I could speak to that just a little bit. It's not really an issue for me per se. However, it's an issue for a lot of people that call us up and say, hey, can you donate some beer to our thing? We just need a few cases. We're a parents network. We're just over the hill here. Do you think maybe we could just come over and get 10 cases of beer for our event? Well, you can come 10 days in a row. You can you can go to the retail store and you can get 10 cases of beer, and that's sure you can do that, but I can't donate to you. If you'd like to go through the trouble, you can go downtown, you can file a bunch of paperwork, you can spend $50, you can wait a couple of months and see if you're going to get approved for your special permit, and then we can approach my distributor and say, hey, would you be willing to engage in this process of donating beer to this special retailer, and then maybe you can. But it's a lot easier if it's a parents network and they're working off a paper thin budget and it's somebody's free time to just say, hey, can I run around to the neighborhood brewery and get a couple of cases for our fundraiser event. That's kind of what that's what the bill is trying to get at. It's not, I don't know the verbiage per se. I'm not versed in legalese, but I know that's the spirit of the bill. And I guess kind of since I have your ear, I don't know if y'all have noticed rising costs out there in the world. We sure have as small breweries. Our paper-thin margins and, the need to be at large volumes right off the gate in order to be profitable has led to a reduced margin for sure. And this bill would go a long way to helping salvage the small number of craft breweries that we have in the state of Georgia. To help keep them viable for years to come. So.
Senator Ginn has a question for you. Senator Ginn?
Yes.
Since you're actually a brewer, let me ask you on.
Well, I'm more the glorified maintenance man.
Okay, whatever you want to call it. But for me, if you got, instead of 100 miles, if you got 10 miles from Grant Park.
Well, from Grant Park, 10 miles covers a lot of territory.
That's what I'm saying.
I think if you're down in, Tifton, Georgia, 10 miles doesn't get you outside of Tifton.
No, that's okay with me.
But I mean,
for me, is 10 miles going to be something you could live with?
I think 10 miles, we would be happy to have it.
Well, you got nothing right now.
Right.
And so for me, Mr. Chairman, if it's okay,
we're not going to probably have time to hear everybody on it, Senator. That is a very good thought. I'm gonna let the author wrap up. Here's our problem. We're literally 30 minutes over in our time, and we've got people missing another important committee meeting trying to get a bill on the floor. I
understand.
I'm not comfortable with this committee making decisions without hearing the full things, and this bill has so much in it. I've got 5 other people signed up to speak. What I think we're going to have to do is let Chairman Huffstetler wrap up a little bit, and then let's just leave this pending. We may be able to come back to it another day. Maybe a House version comes over, or other vehicles. Needs a little bit more thoroughness.
Well, thank you for your time.
I wanted you to be sure, and your industry to be heard, since you've worked hard on this bill for some years.
We do appreciate that. Thank you, sir.
All right, thank you, Mr. Chairman. You did hear about bringing in Anheuser-Busch and Miller, and I used to work for Anheuser-Busch. I mean, we're talking about 4 minutes production of that place. They're not interested in anything about these kind of levels. You did hear from the wholesalers there were 155 craft brewers, and that's correct. There's 364 in North Carolina, a state smaller than us. 550,000 barrels here, 955,000 there. We're way behind them. You'll hear that the world's going to end if we do this. North Carolina's doing it at a much bigger rate, and the world hadn't ended, and the beer business has thrived, and we've created jobs, and we've let the free market get out there and work to create jobs for this industry. And this industry needs to be able to grow just like they can do in that state.
Senator, I appreciate your energy and your efforts. I'm sorry we're so short on time. I did take these in the order they were filed in the Senate, and it is, thank goodness, it's a 2-year process. We will keep you in mind and see what type of vehicles may be available this year, or if it's worthwhile to thrash out some more hearings in the dead time. I need to apologize to Senator Still, Senator Williams. I'm sorry y'all each had a couple of bills that were on our list, but we just didn't have time to get to them before crossover day. I asked if I could, I looked to see if there was room for a meeting tomorrow, but we're pretty well slammed up before noon, and bills have to be out of committee before noon, or I'd try to hear you then. Just don't give up. It's a 2-year process. We'll keep talking and keep looking for other opportunities to advance your interest. With that, we are adjourned for today. Thank you.